Hi everyone, welcome back to Simply Legal. Wow, I always say wow, it has been a while. I'm always thrilled to have you guys on the show every single week. In today's video, I'm going to show you how to win or succeed in a lawsuit or a case, as we like to call them in Uganda. So, let's go. Many of us hear, what is a lawsuit or what is a case? Many people here say, Terry, do you handle cases these days since you're now out of the bar or LDC? Well, I'm almost being enrolled as an advocate, but that will be a story for another time. What we mean by a lawsuit or a case is basically plaintiff versus defendant. What do I mean by this? Who can sue or who can be sued? We always have one party who is bringing a case in court, and we always have the party who the case is being brought against. So in other words, a lawsuit is a mixture or happening of events that takes place in court or behind closed doors or in a court system. We use lawsuits in different jurisdictions, but in Uganda we use what's called a case. So today we're here to look at different aspects of what a case entails and how to succeed in one. I'm going to be very brief in this video, so the biggest tip is going to be at the end. However, before we continue this video, please be sure to hit the subscribe button and hit the notification bell so that you don't miss our videos weekly. And also to add on that, please hit me up on my social media platforms and handles, Terry Kahuma, on Twitter, on Facebook, on WhatsApp, on Instagram, TikTok, and Snapchat these days. So, as we continue, I told you in a case we have two parties. We have the plaintiff, who is the one who brings the case, and we have the defendant. But many cases, these terms seem to confuse people a lot. Let's go back to the Constitution. The Constitution of the Republic of Uganda, in particular Article 50, states that whichever person feels like they have been wronged, or whichever person who feels like his right has been infringed on, may seek redress in a competent court. Now, in this channel, I've talked about court systems in many different videos, some directly and some indirectly. We have court systems, for example, we have the magistrates court, we have the High Court, we have the Supreme Court, and for all the Simply Legal people out there, you already know what court systems are by now. So like I say, we have the plaintiff, and then we have the defendant. So these two are usually versing each other in court, and in most cases, the plaintiff feels like a wrong has been done to him, so he has to come up with all of this evidence, with all his facts of the case, to go to court and verse the defendant. To succeed in a lawsuit in Uganda, you need a number of things. You need a competent lawyer, you need to get your facts right, and you need especially what is called a cause of action. So therefore, what is a cause of action? A cause of action is exactly what the plaintiff should bring in this case. I want to reiterate again. A plaintiff is the one who can sue or who sues in a case, and the defendant is the one who the suit is being brought against. So therefore, we must look at what a cause of action is. In law, I'm going to simplify it for you just like Simply Legal likes to do it for you. A cause of action is basically your right to come and sue someone in court, or what evidence do you have to bring a case in court. A cause of action was defined in the case of Motokov v Auto Garage, which is Motokov versus Auto Garage, or Auto Garage versus Motokov, because this case we need to appeal and everything. However, Motokov v Auto Garage is an East African case. It brought out what a cause of action is, or what we rely on in Uganda to explain what a cause of action is. So it brings out three elements in a cause of action that constitute what the definition says. So basically, a cause of action is a right or a set of events that one has gone through, or a plaintiff has gone through, to then bring a suit against the defendant. What are these three elements in a cause of action? We have the plaintiff must have had a right that he or she should have been enjoyed. Then, this right should have been infringed on or violated by the defendant. And thirdly, this person is then seeking redress from this same set of facts that was infringed on him. So I want to make it very clear for you. A cause of action has three elements or requirements. Number one, there must have been a right that the plaintiff should have enjoyed. Number 2, that right was violated or breached by the defendant. That's why he's taking him to court. And number 3, he is then seeking redress. I keep talking about redress, but redress basically means you're seeking remedies in court. I've spoken about remedies on this channel, so let's not dwell so much into it. However, remedies is the ultimate thing you're going to look for at the end of a suit. So many cases, a cause of action is exactly what is needed to succeed in a lawsuit. The major purpose of this video is not just for the plaintiffs, but also for the defendants. You can use this in reverse to actually avoid you from being sued or to avoid lawsuits on your case. Whether you're a company, whether you are a normal person. In law, we have 2 people. We have natural persons and we have legal persons. A natural person is me and you behind the screen, a simply legal tribe mate, or a legal person is a company or corporations. So therefore, let us now go to exactly what is needed in a... Well, we have been looking at what we need to succeed in a lawsuit, but let's go deeper into the issue. Now that we've established who a plaintiff is, who a defendant is, what a cause of action is, we then look at what is called a plaint. A plaint is a document that explains all your set of facts in a case. Plaint comes out of the word plaintiff. So therefore, the plaint is basically a story, if I can just simplify it for you. A plaint is a very, very important document that you need to have, especially if you're the one instigating a suit or you're the one suing someone. I would just like to reiterate again. A plaint is a document basically stating all the facts and the cause of action as to why you're bringing a suit against the other person. So what law provides for a plaint, my fellow lawyers, and also those who are on this channel in Simply Legal? A plaint is looked at under Order 7 of the Civil Procedure Rules. By the way, I forgot to mention, we have this video talks about how to win or succeed in a suit. However, I'm mainly looking at the civil side. I will handle the criminal side some other time, but in this particular case, I'm looking at the civil suits. So we have Civil Procedure Rules, Civil Procedure Act, all of these govern civil suits in Uganda. Now, a plaint is given under Order 7 of the Civil Procedure Rules of Uganda. It's a really huge book. One time I'll just flash it here and I'll show you guys how the Civil Procedure Rules look and also the Act. So, there are salient features or essentials as to what a plaint should have under Order 7, Rule 1. So, let's just go through them in a brief state so that you can understand what a plaint looks like. A plaint should have a cause of action. Like I've majorly stated, it's a brief facts of a story of what you've been going through. I, Terry Kahuma, I went to Jinja, I was driving a car, I ended up knocking someone's dog, and this person lost his dog. I wanted to pay him, he ended up vandalizing my car. You see how all of these facts are now playing out? So that is exactly what a plaint should have. State from the story from beginning to the end. Now, another salient feature should be the name, residence, and maybe postal address of you, the plaintiff. You should also have the name, address, postal address, or all the details of the defendant. So if I am the one suing the person who vandalized my car, I'll mention that I tried to reason with him but end up vandalizing my car. I'm now suing him for malicious damage to property, or I want damages for my car. So another salient feature should be the facts of the case. I want us to just go through them again. The facts of the case, you need to have the residence of you, the person, the plaintiff, the name and address, also the name and address of the defendant. Another thing is that the plaint should be able to contain the court under which you want to bring this suit under. Most plaints are taken to the magistrate's court or the high court, because those are the courts that are in the beginning process of the entire hierarchy of court system. So the plaint should be able to contain which court you're addressing this matter to. Either it's a magistrate's court, because there are different values of different suits that you're going to bring under each court system. So it must contain the court which you're addressing the case to. It must also address the amount of value the amount of redress you're looking for. It also needs to contain, mostly, I would like to repeat this again, like it must state all the facts that have arisen up to why you're bringing this case. So basically what I'm just trying to say is that a plaintiff should not miss out most of these important essentials, because the moment it misses it, then according to Order 7, Rule 11, the moment a plaintiff does not disclose a cause of action, or it doesn't bring out exactly what you're looking for in court, what happened to you, who you are, your name and address, the name and address of the defendant, the person you're suing, then the judge is just going to say, you know what, it seems this plaintiff is not serious, let's strike out this case. So according to Order 7, Rule 11, the moment a plaintiff does not disclose a proper cause of action and set of facts, and it's missing many of the essential features or necessary requirements of a valid plaint, then it's going to be struck out. The final thing is you need to mention in your plaint the amount of value in terms of monetary value, or the remedies that you're seeking from court. Either you want this person to be imprisoned, or you want money, or you want damages. In most cases, like I said, we're looking at how to win a case, especially in a civil suit or commercial suit. Then you're going to have to mostly look for damages. So let's now go to how to institute a suit in Uganda. Before a suit is actually instituted, the plaintiff, before even coming up with a plaint, or by the time they're done with a plaint, they need to first file to the defendant what's called a notice of intention to sue. A notice of intention to sue. So that is basically your forewarning the defendant that, you know what, I have a case against you and I'm willing to drag you to court. In most cases, we've watched Boston Legal, we have watched Suits, we have watched a number of, especially American movies, British cases, and most people say, I'm dragging you to court, I'm suing you, I'm taking you to court. So whenever they're doing that, they're going to draft, this person and their lawyer or counsel is going to draft what's called a notice of intention to sue. I'm basically telling you that, you know what, I'm stating all my facts in this case, I'm suing you under this, I'm taking you to court because you have committed this crime, you've damaged my property, you've killed my person, anything. That's the notice of intention to sue. You're forewarning them. Then the defendant is then going to reply to that. So a notice of intention to sue is the first thing. Then the defendant is then going to reply. Afterwards, then the defendant will then say, you know what, let us now go to court. So this is the entire court process that I'm explaining to you. In this, I really felt bad that in this channel I've never explained this court process to you before and how to win a lawsuit. By the way, here we are. So after notice of intention to sue is done, then a plaint is done. I guess we're now following all the steps. After a plaint is done, there are accompanying documents which should be done, or which should be made to accompany the plaint. In most cases, this is a list of documents such as an affidavit. Many of you have heard of what's called an affidavit or a statutory declaration. An affidavit is I would call it another plaint. As a law student or an officer of the court, I would like to understand it in that way. An affidavit is more detailed. It's a document where you're going to state every single thing, even more than what is in the plaint. The facts that arose to the case, who I am, I'm an adult of sound mind, my name is Terry Kahuma, this and this. An affidavit is basically backing up what a notice of intent, what a plaint is. So there are also going to be a list of authorities to back up this plaint. List of authorities, like I mentioned earlier, if you are suing in the magistrate's court, then your lawyer or counsel is going to bring a list of authorities. In law we call them authorities, but these are basically statutes. We have the Magistrates Courts Act, we have the Trial and Indictment Act, we have the Judicature Act, and many other laws. I'll not bore you with all the laws because it's simply legal. We like to simplify the law for you. However, if it's the High Court, then we're also going to list a number of authorities or statutes which apply to that court. Like I told you earlier, the plaintiff must be able to state which court I am taking this case to. If, let's say, Moses came to my law firm, Kahuma and Company Advocates, not that it exists, but I'm just saying metaphorically. If he came to my firm and said, you know what, Terry, I have this set of facts, I want to sue this person in that. Then I'm the one going to tell him that, you know what, we need to sue this person, either in the magistrate's court or the high court. So I'm the one to draft a plaint for him according to the story that I've been noting down. Then I draft for him an affidavit, he's the one to sign it, and everything is commissioned by Commissioner for Oaths. We address it to a particular court, either the magistrate's court or the high court. I guess you're now all following. So thereafter, we have what are called summons. So let's go to summons. What exactly are summons? Like the way you hear the English word summon, the court will now do what's called summons. We're now going through the entire court process. We're still continuing. So the plaintiff is then required to extract summons from the court, meaning the court is now going to compel the defendant who has been taken to court, the person who they are suing. The court is now telling the person who they are suing that, you know what, you now need to come and file your statement of defense, or you need to come and file your defense in court. Because, as we all know, the moment you defy court, then that is also a crime in itself. So the moment summons are done, the defense is now going to go to court and file his or her defense, of course under the advisement of your lawyer or counsel. Afterwards, the court is now going to suggest that you guys go for alternative dispute resolution. I've done a video on this alternative dispute resolution. I'm going to leave the link in the description below. I did a video on arbitration and mediation and its benefits. So the court, after 14 days of filing the defense and extraction of summons, then the court is just going to tell the two parties, the plaintiff and the defendant, that, you know what, you guys need to try and sort this out outside court. So try mediation, try arbitration. That's 14 days after the summons have been extracted and the defense has also been filed by the defendant. Once mediation fails, then you guys are going to have to do what's called a scheduling memorandum. Basically, this is going to you're now telling court that, you know what, mediation or arbitration has failed, so we now want to come and take this whole matter to court. After scheduling your case in court, either magistrate's court or a high court or Supreme Court, whatever it is, then you guys, I'm using you guys because I want to simplify all of this for you. The plaintiff and the defendant are then going to go for what's called the hearing. The hearing is the last process in the whole, it's in the last process in the whole prerequisite of court process. We call them pre-trial requirements or pre-trial proceedings. So the hearing date is now set. The moment you now come for the hearing date, the judge is going to be there with their glasses and wig and look at you. Who is the defendant, who is the plaintiff? Plaintiff, where is your lawyer? Bring out your plaint, defense, what you guys have, what's the case about. Now the entire court process starts. So that will be a topic for another day, but I just wanted to show you that this entire court process is extremely vital and it happens in our day-to-day lives. However, now that you've stuck to the end of the video, I wanted to give you the biggest secret to winning a case. So how to win a case is that, first of all, avoid being sued. Be on the right side of the law. Do not ever try and wrong anyone in any way, because Ugandans are now woke. People now know their rights. However, back to the legal side, always know your laws. But if you ever find yourself wanting to institute a suit, you should always know that you need, number one, to do what's called a notice of intention to sue. You need to know your facts. You need to know your cause of action. Why are you bringing this suit against this person? Do you believe you have a right, or do you believe your right was violated? Do you believe the defendant was in the wrong? So I did this video for you to understand all of these aspects. There's a plaintiff, there's a defendant. The law always provides for you rights in a way for you to come and sue if you really believe that you have a right that was breached, a right that was wronged. So that is a way to win a suit in a civil proceeding or in Uganda. So thank you so much for listening to me, guys. Thank you for supporting the channel. And if you ever feel like you need to win as a lawsuit, just I don't know what else to say. Just love watching this video. And for those who are new to my channel, feel free to hit the subscribe button. Feel free to hit the notification bell so that you don't miss any future uploads. I would just like to state again that for lawyers or for people who are part of this channel, who are in the legal world, feel free to talk to me about what I could have missed in terms of authorities, in terms of statutes, in terms of cases. I've mentioned the Civil Procedure Rules, Civil Procedure Act. If there are any cases that I didn't mention, please hit me up in the comment section. And thank you so much for listening to me, guys. I'll see you next time. Avoid being sued. And if you feel like you want to sue someone, I guess I've helped you out in this video. So let's get cracking. Bye. Oh, I forgot to mention the remedies. Guys, I keep forgetting most of these things, but I'm human, and production of these videos actually takes a very long time. This is a bit on and off script. In the final process of the court proceedings, especially all the steps that I've mentioned, from the cause of action to the plaint, to the notice of motion, joint scheduling memorandum, the mediation, please, if you're ever instituting a suit, or if you want to know how to institute a suit or how these cases happen, always make sure that you provide for the remedies. Most lawyers will actually tell you that what you want from this, or we can actually get this out of this. I can see us in the plaint. You can state that we're going to ask the court to ask the defendant to pay us 60 million shillings in damages. I've mentioned damages on this channel before. We have general damages, we have special damages, we have exemplary damages. All of them have different criteria and different requirements for you to qualify for damages. Because this is a civil suit or civil proceedings. So thank you so much for listening to me, guys, and anything you want to talk to me about in a future video, please mention it. I love doing these videos for you guys. I love you, the Simply Legal channel. The energy is going to continue keeping up very high, and let's keep growing. Mwah.